I'm going to talk today about how an individual may wish to prepare if they decide to defend themselves at Major AGAI 67. The point to note is that at deciding officer stage at Major AGAI 67, it is not usual for a legal representative to be allowed to be present to represent the service person and to argue with the findings contained within the Annex C to the Major AGAI 67 report. So an individual may find that they have to represent themselves. They are entitled to consult with a lawyer beforehand, but that consultation is not covered under the AFCLA Armed Forces Criminal Legal Aid Authority legal aid scheme. So it may be that an individual concludes that for whatever reason that they do not wish to instruct a lawyer to prepare the matter for them. And there could be a number of reasons for that. It could of course simply come down to a matter of cost, but it could also come down to the level of sanction that the originating officer is recommending within the Annex C report. So for example, an individual may consider that if the recommended sanction is, for example, a censure, that there is little to be gained by instructing a lawyer, potentially several hundreds of pounds worth of costs, if all that is to be the sanction at the end of the matter is simply a letter of censure. At the other end of the spectrum, of course, an individual may consider that they have to think about instructing a lawyer if the originating officer's recommendation is that they are discharged. In this video, I am going to generalise and go into general areas where an individual may wish to defend themselves in front of the deciding officer, who will typically be their commanding officer. So there's two main areas in which an individual may wish to focus their attention. The first is the facts, and the second is the procedure. Dealing with the facts, it's important to note that the standard of proof at Major AGAI 67 is considerably lower than it is at court-martial, or even that it is at CO's summary hearing. At court-martial and at CO's summary hearing, the test should be beyond reasonable doubt. At Major AGAI 67, the test is on the balance of probabilities. Is it more likely than not? And that immediately puts an individual at a disadvantage, because a commanding officer or deciding officer only has to be persuaded that it's more likely than not in order to have a finding. So looking at the facts, and again I can only deal with generalisations, it might be, for example, that the facts are simply wrong, or that they've been misinterpreted, or that the originating officer hasn't investigated all the facts fully. So it might be that an individual looks at the Annex C report and decides this isn't right, that isn't right, that isn't a correct version of what happened. And if that's the case, then an individual may wish to challenge the facts and seek to put their own evidence forward in front of the deciding officer. The second area is procedure, and this could be separate to the facts, or it could be in conjunction with the facts. And that is, has the originating officer's report, has the procedure been followed in preparing the report, the timelines? Has the individual been given sufficient notice? Have they been given sufficient time to prepare? Have they been appointed an assisting officer? Have the rules been followed in Major AGAI 67? And if they haven't, then an individual may wish to challenge the legality of the Major AGAI 67 hearing on the basis that the rules themselves, the procedure themselves, have not been followed. Therefore, when an individual represents themselves or decides to represent themselves or to prepare the matter for CO's Major AGAI 67 hearing on their own, the two areas in which they may wish to focus on are first, the facts, and second, the procedure.